Welcome to Case by Case. This is a podcast series brought to you by Luke Zadkovich and Calum Chain of Xylofluid Zadkovich. How are you today, Calum?
I'm good, Luke. I was just thinking that maybe we need a jingle for our intros.
Don't we have one?
I think we have some intro music, but I was just thinking of something kind of case by case in a song style.
Okay, well, why don't you do that for next one? I like to hear your beatbox, case by case intro. In any event, how are you? How are you doing?
I'm good. And I'm excited that once again we have a guest on the show.
Yeah, me too. Eva-Maria Mayer. How are you, Eva?
Hi, everyone. I'm well. Thanks for having me on. Sounds like this is going to be an exciting little podcast.
Yeah, you're getting an early taste. We like to get into the law and get serious on what we're talking about. But yeah, we like a bit of humor with our podcast. So Calum, I think speaking of humor, I think maybe our last album cover on LinkedIn was probably a step too far. But I'm blaming Rachel. Shout out to Rachel for that. Rachel's our marketing guru and helps us with editing and putting together this podcast. So jokes aside, thanks, Rachel. We do really appreciate everything you do for us. So today's episode is different in a few ways, actually. One, we've got Eva with us. Eva is one of our New York associates. I'm delighted that Eva can join us. For those of you who have not met Eva before, she's been involved in all sorts of interesting cases in the shipping space, commodities space, general commercial litigation, and some advisory work as well. Eva went to Tulane University and did a JD there and was involved in the Maritime Law Journal and has a number of positions, one of which is a secretary of the Oceans Committee with the Maritime Law Association of the US. So really interested to hear your insights today, Eva.
Yeah, thanks. Thanks for introducing me like that. Sounds like I've done a lot in the past couple of years. But yeah, so I've been with you guys for 3 years and feel like I've learned a lot. So I'm excited to share some insights today.
Excellent. Good stuff. And you all who have been listening in before know Calum. Calum's one of our senior associates in England, and he'll be giving the English law perspective today, and Eva will be giving the US law perspective. So rather than talk about a recent case hot off the press, we thought what we would do today is look at a key point of difference in US and English law and center that around a scenario, and then look at two of the leading cases or two key cases on this point as a point of difference, with Eva giving the US position and Calum giving the English position. So if that sounds good to you, Calum and Eva, I might jump into setting out the scenario.
Yeah, let's jump into it.
All right. So this is the situation. So as I say, I'm going to kind of set up a scenario, and then we'll throw to the leading US case on it, and Eva will talk about that, and we can all chime in on that, and then Calum will jump into the English side. So the scenario we're looking at here is, imagine you've got two parties to a contract, party A and party B. And let's say party A is the vessel owner and party B is the charterer, and we've got let's say it's a voyage charter party. So under the terms of that charter party, certain specific claims are time barred, let's say after a certain period of time, and perhaps those could be the demurrage claims. So let's say some claims, the demurrage claims, are time barred under that contract, and other claims are not contractually time barred. They may eventually become time barred, as a matter of law after 6 years or what have you, depending on the jurisdiction. But let's say at the moment that we're looking at the scenario, some claims not time barred. Then we're looking at party B, let's say, brings a claim against party A for non-time barred claims. So they've got some straightforward claims that are not subject to any time bars. They're good to go. They bring them against party A. Party A then says, well, it wants to use some of its time barred claims as a defense to that claim being brought by party B. So in other words, can party A, as a shield, completely as a defense, they couldn't bring this claim affirmatively. They couldn't bring it in a positive way because it's time barred. But can they use the time barred claim that they didn't bring against party B as a defense to that claim, that incoming claim again that's being brought by party B against party A, and either use a set-off type defense, or equitable set-off type defense, or a defense that's known as recoupment. And really that's the question. In a scenario where you're facing an incoming claim, can you run as a defense a time-barred claim that you cannot bring otherwise as an affirmative claim? And we will look at that, I think, from both the US perspective and the English perspective. And it may make sense, Eva, if you lead off this discussion from a US perspective.
Sure. So the short answer in the US is yes, you can. And Calum will get into the English perspective here, and I'm happy to talk a little bit about the US perspective. Probably best to just use a specific case. So I've looked at distribution services versus Eddie Parker interests. It's a 1990s Court of Appeals in the Fifth Circuit case, and it's a specific maritime claim case. So to give some background, exactly how Luke explained with party A, party B, here it's distribution services trying to bring a claim for breach of contract for carriage of certain goods from China to Texas, and New Trends as party B is bringing a counterclaim for damages to the goods. DSL files a motion to dismiss saying New Trends can't bring this counterclaim because it's time barred. So this goes to the question of time bar. When does one apply? When does another one apply? This is a specific maritime case. And so COGSA, Carriage of Goods by the Sea Act, applies, which has a 1-year statute of limitation. So COGSA says that after 1 year of discharge, you cannot no longer bring any claims for liability to loss or damages to the cargo. And New Trends did not dispute that. They did not dispute actually that if they were to bring this claim in an affirmative manner, their claim would be time barred. However, they were saying, we're not bringing this affirmatively. We're bringing this as a defense to DSL's breach of contract claim by way of offset or recoupment. However, in the initial case, the district court agreed with DSL saying that, no, your claim is time barred, whether you're using it as affirmative claim or as a defense, your time has run. And so New Trends brought an appeal, and this is the 1990 the Circuit Court of Appeal. And I'm just going to quote a little bit from them as to how they define recoupment under US law. And it says, recoupment is the defense that goes to the foundation of the plaintiff's claim by deducting from plaintiff's recovery all just allowances or demands accruing to the defendant with respect to the same contract or transaction. So not only can you only bring a technically time-barred claim as a defense, you can also only use that type of defense when it is regarding to this exact same transaction or contract that the plaintiff's claim arises from.
And that language, that's similar language that you see in set-off law as well, where set-offs generally are restricted to the same contract and transaction. This concept of recoupment is not a phrase that's seen in English law. There is some equitable remedies, but we'll get onto those in a moment. But this, I think it's useful to read that out, Eva, that recoupment concept. And so what it is, it's basically, as I understand it, that for the plaintiff to be able to make their recovery, so here DSL, they have to really be accounting for all the costs that go with making that recovery. And one of them is counterclaims that could have been brought against them that were not brought against them. And yes, now they're time barred, but this concept is that, the all just allowances and demands, that concept captures, as I understand, the incoming or the defensive time barred claims that New Trends could have brought.
Yeah, that's right, Luke. It kind of ultimately comes down to fairness, right? Just because you happen to have a longer time shouldn't mean that you can abuse that. And I'll go into an example of that later on. But yeah, it's purely a defense. You cannot bring it in a way as a second bite at the apple or a way to skirt a statute of limitations. But it's really truly, as you said, just a shield.
It's also because the nature of recoupment is a defense, right? So statutes of limitations and those types of provisions, at least on the US side, dealing with preventing the ability of a plaintiff, or, when in a plaintiff's position, from bringing a claim, from commencing a claim. And so they're really aimed at the prevention of pursuing a claim. That's how this recoupment, concept works. And so recoupment is it's more of a defense. So the statute of limitations doesn't really impinge upon recoupment in its concept, if you like. And I think that's what underpins the whole rationale of this judgment.
Yep, that's exactly right. So the whole idea of statute of limitations really goes to making sure that no stale claims come into court. Once a claim has made it into court and it's found to be timely, then trying to apply a statute of limitations to certain aspects of that lawsuit no longer fulfills the purpose of a statute of limitations. It actually just prevents parties from fully litigating all of the issues. The court actually said exactly that. If the litigation is not stale, then no issues can be considered stale in the litigation. So it's kind of it's a way to make sure that the statute of limitation actually just gets applied for its purpose and then not abused to somehow limit a defendant, especially in a situation where, like you mentioned in the introduction, you have one party who has, let's say, a 6-year statute of limitation to bring their claim, and the other party has a 2-year statute of limitation to bring their claim. So technically, the party with the 6-year statute of limitations could bring their claim 2 years and a day after the event and prevent the other party from bringing their claim. So
if I can just jump in there though, Eva, are they preventing the other party from bringing their claim, or is the other party simply missing the opportunity to bring a claim, after which point their right to what they say they're entitled to elapses?
Well, yes, of course, the other party had 2 years to bring their claim. And I think that's kind of a discussion. I think that's where we differ between the US and English law. The idea of that under English law, not only the claim, but also the defense is extinguished after the statute of limitation expires. In the US, it's been found that it's really just the claim, but the defense can still stand. The facts upon which the original claim was created are not extinguished, in the sense that they can no longer be used as a defense.
I think that's broadly true for the position in the UK. The key difference is that this concept of recoupment, this defense of recoupment, doesn't exist in the UK. So you have to fit the defense into a slightly different category. And I think what was interesting in both cases, and I'll come on to this when we talk through the English law judgment, what was interesting in both cases was that they sought to characterize the nature of the time bar. In the US law case, and Eva and Luke, please correct me if I'm wrong on this, but in the US law case, they found that the nature of the time bar wasn't extinguishing any right that might exist. It was simply barring a plaintiff from bringing a claim after that time.
That's exactly right. That's what I was trying to get at, but you said it better. Thanks, Calum. Yeah, so that's really it for as a quick overview from me on this US case. But yeah, essentially, big picture is that you can use a claim as a defense even when it's been time barred as an affirmative claim, as long as the original claim that the plaintiff is bringing into court is timely. So that's really important. If that one is also time barred, you're out of luck. But of course, you're also then no longer defending a claim. Yeah.
So what do you make? I throw this to both of you. What do you make of the underlying effect of that, or the rationale for it? Because it strikes me that on the US approach, the courts are basically not encouraging claimants to come to court and pursue claims if for whatever reason they don't want to. And remember, costs are generally not recoverable on a US analysis in a normal situation. And so there's almost this, well, you don't have to bring your claim to court and litigate it to ripen it and for it to remain, even if there's a statutory limitation that may bar you to bring that claim. You can still rest on it and use it as a defense in due course if the other party then brings a claim against you. I can see some rationale in that. I can also, of course, play devil's advocate and see the flip side. But I'm interested in what your take is on that.
I think, yeah, you have to look at the overall purpose, as you mentioned. I think the overall purpose seems to make sure that people are not forced to litigate when they don't want to. And if they choose not to, for whatever reason, at least still can use their claim as a defense if time has run at that point. I think it's a way to balance the playing field in a way that where you have different lengths of statute of limitations. I guess the law has decided at some point that one claim should exist for longer than another. But then the defense to that claim, if it happens to be longer than your claim, should not also be extinguished because you chose not to bring your claim. And I think it's a way to make sure that things are not over litigated, which is kind of ironic because in the US, you can't say that you don't over litigate here. But yeah, it's a way to keep the courts clear of filing suits for the sake of maintaining your rights or out of fear that someone might bring an action against you later on that has a longer statute of limitation.
Yeah, I think I see it the other way. And
Good.
I think for me, there are 2 points. The first is that if I assert a right or an entitlement which is disputed by a counterparty, then there has to come a point at which there's a reckoning of whether or not that right exists for me, or alternatively that right doesn't exist. And if I've agreed with somebody that the period in which I can raise a claim to determine whether or not I can insist on that right or entitlement elapses, then I lose that right or entitlement. And I find it odd that I could sort of halfway have that right or entitlement. Let's imagine a situation where the counterclaim or the defense of recoupment relates to an entitlement which is in excess of the original claim. You could have this slightly odd situation where I'm entitled to refer to that claim, and in doing so, it feels to me as though it has to be taken that I have an entitlement to something. If I'm using this as a defense to a claim, and an otherwise bona fide claim that somebody has against me is being cut down because of an entitlement that I say I have in recoupment, it's odd to me that I then can't use it to get the entirety of that entitlement. I'm pegged at my recovery for that entitlement that I say exists is pegged at the value of their otherwise bona fide claim against me. That's uncomfortable for me.
Yeah.
I see that point, and I see that point, but I think ultimately, I think it's looking at it from two different perspectives, right? It's, I suppose, looking at it from a higher perspective of overall fairness as to, making things right in the universe versus taking a position of an individual in a litigation, I suppose, is how I can justify the perspective. But I definitely understand your position that where I think the example would be, I don't know, I'm asking you to pay outstanding freight and your claim would have been it's unreasonably high. And then you can bring as a defense your unreasonably high claim. And ultimately we'd really be litigating the entire, you don't always be litigating in an affirmative sense, the unreasonably high freight claim.
Well, exactly.
Yeah, I see all that. Does it make a difference? Because Calum, in your kind of justification for your position, with which I certainly see that, does it make a difference as to what has been expressly agreed here? Because it strikes me that part of your concern here is, well, if the parties have agreed to something and part of that agreement is the time period within which to assert that right and crystallize that right and have it decided upon, then it's only fair that if you don't do that, then the right falls away. It's extinguished. It no longer exists anymore. Is there some difference between that and a statute of limitations of 6 years or whatever it is? It would have to be the earlier one to buy. So say the COGSA period. Now it may come in by agreement, so we can get into nuance on the debate. But looking at it from the US perspective, and again, one of the rationales for the decision, as I understood it, was that recoupment is a defense. We're talking about statutory limitations which are aimed at claims, and so they're not necessarily aimed at defenses as well. And if the Act is not dealing with, defenses expressly, Is that not a point of difference?
I see that point of difference, and I find that an equally uncomfortable argument from the other side, because it makes a lot of sense to me. If let's imagine two time bars phrased differently, so they're both contracts that you have to just interpret as contractual provisions. One of them says that any claim made in respect of certain losses will be deemed waived and barred. And the other one says any entitlement in respect of certain losses is extinguished. And both of them say after 1 year. Then taking the contractual language, is that the same thing? Is it the same thing to say that a right is extinguished or an entitlement is extinguished as it is to say that a claim after a certain period will be deemed waived and barred? And I think there is nuance that perhaps isn't reflected in English law as it stands. And I can see why a system like recoupment could make sense, because contractually you could argue that the terms, if I bring a claim and that claim is deemed waived and barred, that's one thing. But what about if I bring a defense on an entitlement that otherwise would have been deemed waived and barred as a claim? Then I can see how there's a distinction between those two things. If I don't have a right, if the right is extinguished, then I don't like the fact that it can be resuscitated and used only as a defense. I think that creates an arbitrary distinction. It might be a good time to talk through the English law one, because
let's do that.
Yeah, it's a fascinating case. And this is the Aries. It's 1977 House of Lords judgment, the leading judgment given by Lord Wilberforce. And it's one of these interesting cases where, despite all being in agreement, I think all five lords give some substantive comment, maybe three or four at least of the lords do. And this is a case where there was a voyage charter party from it's not clear exactly where, but somewhere in the Arabian Gulf to Rotterdam. And the contract incorporated the Hague Rules. The freight was based on the cargo amount as loaded, and there was a certain amount of freight that was payable on that basis. And the charterers alleged on discharge that there was a short delivery. And they said that they therefore had a claim for $30,000. The freight was paid by the charterers in full, but they made it clear they disagreed with paying freight in full. So they said, we are paying you the full freight, but actually you've delivered short here, and we're entitled to $30,000 back from that freight. There was then a claim commenced, and the defense and counterclaim was served after 1 year. And the wording in the Hague Rules prevents bringing the claim after 1 year from discharge. So there were 2 points that were not in dispute, and that went all the way to the House of Lords with these 2 points not being disputed. The first was that the charterers had an arguable claim absent the time bar for this $30,000. And the second point was that their claim was not commenced within that 12-month period. And the House of Lords said, you cannot use that claim to reduce the freight. You can't use it as a defense to the freight that's paid, and you can't use it as a counterclaim against which you then set off the $30,000. And there were a number of different arguments run. There are a few points particularly of interest in the House of Lords judgment. The most relevant for this one was that the House of Lords, Lord Wilberforce, actually refers directly to recoupment in US law, and essentially saying that the laws of the US and English law are distinguished on this point. But I thought it was interesting that this point came up in Lord Wilberforce's judgment. And the second point I thought that was particularly interesting was that Lord Wilberforce said that he saw the wording of the Hague Rules, which is identical, or at least material identical to the wording of US COGSA section 3.6 on the time bar point. He said that that wording to him was in the nature of extinguishing the right in its entirety, which was a different decision to what the judge said in the Fifth Circuit case that Eva has discussed. So I thought that was an interesting point of difference, and actually wasn't something that all the other lords agreed on. All the lords held that you were not entitled to set off this 30,000, this time-barred counterclaim. But there was difference of opinion on whether the wording in the Hague Rules had the effect of barring a claim, or alternatively, whether it had the effect of extinguishing the right.
Yeah, and I find that quite interesting, because it could well be that the barring provision, let's say, comes from a statute. The barring provision could lead to different results. So if the barring provision made it clear that it was extinguishing the right, then, we have the decision in the Aries, and I see the rationale for that. If the statutory provision was aimed more towards, the inability to bring a claim, then, you can see how you could get into the kinds of debates that you've got on the US side. And I think vice versa, on a US perspective, if you had hypothetically, some statute that clearly says, well, recoupment isn't a defense, or can't be used as a defense, or words to that effect, by saying that the underlying rights and their enforcement or their use is extinguished, then it's difficult to see how the recoupment defense reconciles with that.
Yes, there is. I realized when I was going through the facts there, I misstated them slightly in a way which is quite important. The charterers did not pay the 30,000 that they said they were entitled to. And that's significant because the charterers then said, well, why would we ever have commenced this claim? Why would we ever have taken the step of commencing a claim to demonstrate an entitlement to monies that we already have? We've withheld these monies from freight, so we're in the money. And the last thing we need to then do is go to the courts. And this goes to the point that you and Eva were discussing about, does being strict on a time bar incentivize people to rush off to the courts to try and make sure that they benefit from an entitlement that needs to be recorded by a decision?
Well, I've got a point on that, and I think that there's a practice point here for practitioners, and a difference between England and the US. In England, it is more common to seek declaratory orders, judgments, orders from tribunals or courts on rights. And the English courts for many, many years, going back to the 1850s, quite accustomed to having controversies. There needs to be a proper controversy, but having controversies decided upon by way of declaration. So you might not be bringing a positive claim to recover damages and actual money, but you may be seeking a declaration as to your rights. That's much less common in the US. I'm not saying it's entirely not available, but it's difficult, and it's certainly not done routinely. It's a topic I've discussed with one of our partners, Ed Floyd, at length, where I know I've had cases where we've been wanting to go for a declaration, could even be to protect time and to crystallize a right and have that decided, and it's not as easy. There are circumstances in the United States where you may be able to seek a declaration or declaratory relief under a statute, but you have a statutory foundation for bringing that type of suit. But it is much less common, and I just wonder whether there's, not that these decisions go into that per se, but whether there's an interplay there between a kind of traditional English approach to some of these questions and how controversies should be resolved with the US approach to that type of point as well.
Very interesting thoughts. And I think it goes to, there are some very fundamental differences, I think, between practice in the US and practice under English law, including to some extent the nature of dispute resolution entirely. And this is maybe coming from a slightly ignorant place, because I'm not US law qualified, but I'm involved in some of the US litigation, and it strikes me that it can be slightly more confrontational than I think actually both can be equally confrontational, but I think there's a notion in English law that the style of dispute resolution is not intended to be confrontational. I think it winds up being confrontational, but I think that there's a kind of sense that it's perhaps meant to be, in a maybe kind of quaint British way, a relatively non-confrontational way to resolve a dispute.
Yeah.
In which case, asking the court to make an order for something which you're entitled to is a perfectly ordinary thing to be doing.
Mm-hmm. But I do think that there's a parallel there. I do think the kind of decision that we get, or the difference, this distinction we've identified on the substantive point, may also be reflected in some of the procedural differences as well. I thought it was also interesting in the Aries case that one of the lords was, focusing on the fact that this was a law or a rule that had been part of the law in England for a long time, and the parties contracted on that basis They knew where they stood. They could have asserted their rights if they wanted to and have them ruled upon. And it's really not for the courts to get involved in that. It's a matter for Parliament and for statute to change those types of rights, and presumably they would do so prospectively, not retrospectively. And so, you need to kind of look at these questions as at the time the contract was formed, and in the statutory framework and the status of the law at that time. I thought that was an interesting point too.
It is, and I think that we see this quite a lot in English law. We certainly used to see it with the interaction between English law and European law, where there was if there was some English legislation or a UK legislation that conflicted with European law, then there were positions you could be in as an individual or as a company where you could go to the court, ultimately get to the Supreme Court or the European Court of Justice, and you could say this law which is being wielded over me is contrary to European legislation. And the court basically had two options. One is to say, actually, we can read this law in the light of the European legislation and therefore give you the remedy you're seeking. Or alternatively, we actually can't read this law in light of the European legislation, in which case you, the individual who's brought this whole claim, gets nothing. But we do then go back to Parliament and ask them to change the law. And I thought that was a slightly unfair conclusion at the end, at the termination of lengthy litigation.
Yeah, exactly. Well, let's wrap it up. I'm not sure it's been quite a boxing match, but we've had some sparring back and forth between the US and the English approach on this one, and there most certainly is a point of difference on this. I think my own view is it's good to know that recoupment defense is there, because you can imagine cases where you're bang out of time on bringing your claim, and then out of the blue, your client's serve with a claim long after the event, and you're thinking, oh no, we haven't protected our own position, and recoupment may just come in to save some of those cases. So it's a really key point to know and just keep in the backpack if ever needed. Any final thoughts, Eva or Calum?
No final thoughts, just very interesting how these types of things can be so different and then others are so similar. Just how the law develops kind of on the need and context of where it's being applied. Very interesting to me.
I totally agree with that. I think that's a good place for us to land.
All right. Well, thank you both for your time. I've very much enjoyed this discussion. I hope all of you listeners out there have taken something away from today. If you've got any follow-up questions on these topics and you'd like to discuss it with any of us, please do reach out. We welcome the approaches. Thank you for listening in. And if you'd like to get more of these podcasts coming straight into your podcast feed, please do click on the subscribe button, whether you're on Spotify or Apple Podcasts. We're really grateful to have you listen in. So until next time, take care.